All right, welcome back. This is Patents 2 Part 3, and we're in the textbook at basically everything after page 733. And you'll see that I left on the board these various characteristics of what is patentable under the Act. As you'll recall, right, we were thus far until under the second criterion. So as we said, you have to have patentable subject matter, which is an invention that falls under the definition of Section 2 of the Act. And what is that? We saw last week that there's a number of things that are said to be patentable subject matter, the most generic of which is composition of matter. Then we said that there's various exclusions that are said to be non-patentable subject matter. These are the result of what the court said or what the Act says, right? And in the pages that we're discussing here, right, you have two further exclusions that are discussed, which we won't look at in great detail or even at all, which are first, right, means of treatment. And so you're told that there's an exclusion for a means of treatment of an illness, but then you're told that this exclusion doesn't really exist because oftentimes you're able to patent a means of treatment. For instance, a drug, as we said, is patentable even though there's this exclusion for means of treatment, and then you have this other exclusion for forms of energy. So we get into these other characteristics because we spent, right, a week and a half and more looking at what is patentable subject matter. We said you have to have patentable subject matter. You have to have an invention that is of the kind that falls under the various headings that are provided for under the Act, right? And you also have to not fall under the various things that are excluded, that are said to be non-patentable under the Act. Well, that's very fun, but then, it still has to be an invention. A composition of matter in itself is patentable subject matter, but it's not an invention, entirely, right? You also have to have these other three characteristics, which are cumulative. So there's four, right? The first is patentable subject matter. Then you have to meet the other ones, which are novelty, usefulness, and nonobviousness, which are the ones that we are going to look at now. First, utility, right? They're not in that order, right? But the first one we look at is utility. What does it mean to be useful, right? Well, you have basically two cases, right? So you have the Teva case, the Apotex case, again, two very large and wealthy drug companies that fight over things. These are typically the people who are subject to patent law. And you have this test of the scintilla of utility. So what does that mean? Well, first it means that you don't need much utility at all. As I said, it's a matter of it being commercially useful. It, being something that you can sell in the marketplace. How do we determine that it's useful? As I've said many times, right? It's something that solves a problem for people, and how do we know that? We know that because people give you their money for it. Again, though, it doesn't have to be a lot of money. It doesn't have to be a lot of people, right? That's not really what the test says. In fact, it just has to be a scintilla of utility, a little utility, right? Doesn't have to be the groundbreaking cure for treatment that's going to make you tens of billions of dollars. It just has to have some utility in the sense that some people are going to buy it for some money. Importantly, though, it has to do what you say it does. So it has to be the utility that you said it has. So if you invent a drug that is a treatment for something, right, and then they give you a patent because they say that's great, right? If it turns out later on that it is not useful in that way, that it doesn't do that, but it does something else, that does not count. So it's a scintilla of utility, but the correct type of utility, and more specifically the one that you claim it is. So if you claim it does something, it has to be useful in the way you claim that it is useful, not in some other way, and even if it meets usefulness in some other way, that does not count. Quite importantly, right, when is that? It is at the time of filing. So you can't just blindly file a patent application that says my drug's going to cure something before you're done actually proving that. And then later on you say, well, we proved it does have utility that again does not count. The time where we assess this is at the time of application. So at the time of application, it has to have the utility that you say it has. If it doesn't, even though later on it turns out to have it, that does not count. And one of the reasons, right, that we don't necessarily look at all that much is that we don't want people to file patent applications, right, blindly. Otherwise, drug companies would file patent applications for all sorts of reasons, basically to preempt their competitors, right? They would get protection on something even if later on it turned out to be wrong, right? In the meantime, they could get in the way of their competitors. It's not what the Patent Act is for, and so we want you to have proven your thing at the time you're claiming that it has utility. The other thing to think about, right, is that it's only a matter of a little bit of utility. That doesn't get into broader concerns, right? It just means that people are willing to buy it, basically. Some people for some money. It doesn't have to be a commercial success. So we don't look at whether it's a good thing, right, broadly speaking. And more importantly, we don't look at whether, right, the positive effects, the usefulness, are worth the potential negative effects. These things are not part of the test. And so you might have something that does more harm than good. If the good that it does, people are willing to pay for, you're protected because you meet the criterion of usefulness. Then at page 754, right, you have this idea of the promise of the patent, as I said, which is that it has to do what you say it does. So if later on it does more, right, that's not protected. If it does less, you're not protected at all, because there's no proportionality there. So if you say it does something and then it does half of that, you're not protected for half, you're not protected at all. Second criterion that we look at in the textbook is novelty, right? What's novelty again? It has to be an invention. It has to be something you come up with that people did not come up with before. And basically, right, that gets us back to this bargain that we looked at multiple times, where we want people to invent things and we want them to let us know, right? Not 20 years from now, so that A, people can use it, and B, people can come up with their own stuff with it and therefore advance society. One of the things that might be a barrier to novelty is what we call anticipation. And that's important because anticipation is going to be an exception to novelty. And there is a distinction to be drawn here, right? If you invent something, right, and then you're just some nice person that doesn't want to make any money, and you just tell everybody about it, right? Well then, right, 2 years from then, everyone's talked about it. It might have become obvious because it's part of what we call the state of the art. It's part of the discipline that everyone knows about. It's common knowledge of, again, the positas, the people reasonably skilled in the art, and therefore it might have become obvious. It's one barrier. But you need it to kind of spread before it's obvious. There's a way for you to be stuck if you make a disclosure under novelty. And that's going to happen even though there isn't a whole lot of people who know about it. So there's an exception in the Act that says basically for a 1-year period, you cannot have disclosed a thing. So if you disclose the thing more than 1 year before you file, again, this is important, right? All this is about the moment of filing. From the time you filed your application, you cannot get a patent because you don't meet novelty, because you told people about it, right? And that's the doctrine of anticipation, which we look at under the Apotex case, right? And what does anticipation mean, right? Anticipation has two aspects to it, right? First, really what, and then second, how. And there's differing standards to both of these things, right? So there are two things that you're disclosing to the person, right? When you're making a public disclosure. First, what your invention is. And that has to be clear. That's what the court says. There's no guessing, there's no interpretation, it has to be clear. For it to count under anticipation and therefore not be novel, it has to be clear what your invention is, right? It has to be clear, not subject to interpretation. It's one thing. Then, right, in terms of, say, making your invention, so the how, that doesn't have to be that obvious. And so, you don't have to provide all the detailed instruction for someone to copy your invention. What's important is that in the end they can. And in the end they make something that would otherwise be infringing, right? They make your thing in the end, and the way they've made it, or the resulting product that they come up with, is what you would have been protected for under your monopoly if you had a patent. That counts under anticipation. So the how is more subject to interpretation, right? So there is some guessing there, right? So the posita is going to be able to do some experimentation, spend some time on it before they can come up with your invention, and that's still anticipation. So there's no leeway into what you've disclosed, into what your invention is as disclosed. There is some leeway as to making it or making it work, right? In terms of what the posita can do, how much they can guess or put some thought into it, and still for it to count as anticipation and therefore is not novel. That's also what we call enablement, right? Enablement of what? Enablement of the posita to make the thing. And you have this standard of undue burden, right? And what is that? Well, it's the standard of how much effort the person can put. As I said, there's some guessing that's okay. There's some, thought, as to what you haven't provided as instructions for, say, making a snowmobile that's allowed. Too much isn't. Undue burden isn't. Too much thinking, too much effort isn't. And you're told that that is both subject to, again, the posita. So the person's going to be expected to use their knowledge, right? They're a person reasonably skilled in the art. So in guessing and making effort, they're thought to be, in applying their knowledge, their knowledge of the art, of the discipline. And you're told that that it doesn't necessarily mean the same thing for two different inventions. So the burden that is considered undue is going to depend on what the due burden is. It's going to depend on how much effort typically is put into making something. For instance, if making a drug is really hard, right, or is typically the subject of a lot of effort, then we'll expect the posita to make more effort in making your thing, right, for the disclosure to count. Correspondingly, if it's not, or conversely, if it's on the other end of the spectrum, if it's an industry where there isn't much effort made, then you're going to have provided pretty specific instructions in your disclosure to the posita for it to count as having been disclosed under anticipation. And again, what's anticipation? It makes it not novel. And therefore, doesn't meet one of the 4 criteria to get a patent, and therefore you don't get it. Significantly, right, in the Sanofi case, right, in the Abbott Laboratory case, page 762, you're told, and that's basically a corollary of what I've said, that there is no requirement of intent. So therefore, this disclosure there doesn't have to be intentional, right? Obviously, if someone steals your thing, there might be some other concerns there. But, you might not have intended to disclose your invention, right? But still, the period runs, the 1 year runs, and you have to go register your patent. There is no intent requirement. You don't have to have intentionally disclosed your thing. You just have to have disclosed your thing. Another issue that's discussed pretty briefly is double patenting. And that's discussed in far less words than are necessary for you to understand it, so we won't look at it in great depth. But essentially, double patenting is not allowed. Of course, because you're walling off the thing. If you're inventing something, right, there's a wall around it, you can't invent it again. Because then, for all the reasons we said, it's not new, it's no longer non-obvious because it's already patented, people know about it, right? It becomes not novel, known, but protected for 20 years. The distinction is going to be, right, that in double patenting, when you're assessing the second patent, you don't look at the general skill in the art. So if you're trying to get a patent in the first place, right, the posita is presumed to know about everything that's patented, right? At least everything that a normal, reasonable person skilled in the arts would know about. When you're doing double patenting, that's not true. They just have common knowledge and the first patent. And that's how you assess whether the second patent is valid or not. Not by virtue of every other patent, but by virtue only of the one you're comparing with. Again, that's beyond the scope of the course. Third requirement, right, is non-obviousness. As we said, it has to be non-obvious, right? And what is it obvious to? Not just any person walking down the street, a posita, a person reasonably skilled in the arts that is going to have the knowledge that is imputed to such a person. It's going to have the same knowledge as a normal expert, as a person reasonably skilled in their discipline.